My name is Amanda Akem and I will be advising Rhiannon as to whether she can claim the bonus awarded at her workplace, Crate Ltd. In order to do so, it's important to establish whether Rhiannon is an employee working under a contract of services rather than an independent contractor working for a contract for services, as employees have more rights than independent contractors within a company. To establish the possibility of Rhiannon claiming employee status, it's important to look at statutory definitions. Under Section 230, subsection 1 of the Employment Rights Act 1996, it defines an employee as an individual who has entered into or works under a contract of employment. Now, a contract of employment is defined under Section 230, subsection 2 of the Employment Rights Act 1996 as a contract of service or apprenticeship, whether expressed or implied, whether oral or in writing. However, as you can see that these definitions are very vague, therefore we need to look to the circumstances of the case. The contract itself will be construed against what actually happens in practice to see whether there's an existence of a sham. And this is from the case of Auto-Cleanse and Fletcher. The courts have established various tests from case law to determine whether an individual is an employee or not. So we can use this test in this circumstance. For example, we have what we call the control test, which is a question of whether and how much control Crate has over Rhiannon. We also have the integration test, which is a question of can it be said that Rhiannon performs an integral service for Crate. This is from the case of Stevenson, Jordan and MacDonald and Evans, and we can say that yes, she does perform an integral service for the company, as without her the ordering process would not be commenced. Also, we have the economic test, which establishes whether Rhiannon is actually in business for herself or whether she's in business for the actual company. And automatically we can just strike this out because she's working for a company, she's providing her services, and it's for their own benefit. However, the two most important tests form what we call the irreducible minimum, the multiple tests and mutuality of obligation, of which both are questions of fact, not law. In the leading case of Ready Mix Concrete, Ministry of Pensions and National Insurance, 1968, it lays down the three criteria necessary for the multiple test. Now, the first requirement is that there must be personal service. Does Rhiannon provide personal service for Crate? Rhiannon is a software designer and she assists the company in their ordering process. She herself actually has to do this job. So therefore we can say that she does provide a personal service. However, the facts are still silent on issues relating to substitution. Is it possible for her to provide a replacement if, for example, she couldn't come in? If she's more likely to provide a replacement, it is pointing towards the direction that she is an independent contractor. However, if the company provides their own replacement, it highlights the fact that she's more likely to be an employee. And the control test has been encroached into the multiple test, which helps to formulate the second hurdle, which must be satisfied. So the question is, how much control does Crate have over Rhiannon? Now, the facts do indicate that they have a lot of control in one respect for her being an employee, and it also indicates that they may not have as much control. So let's go through the points that indicate that they do have control for her. She has to work a minimum of 20 hours per week. Therefore, there is an expectation that she's going to work those hours, and that's in the case of equestrian string fellows. She has to work on the company's premises, so that just shows that they have control as to where she works, and that's in the case of Nethermere and Gardner. The company, Crate, provide her with laptops and a desk, therefore they're providing her tools for her to be able to do her job. That is from the case of Willie and Minister of Social Security. They also pay her sick pay and holiday pay. That also indicates an employment relationship, and that was from the case of Global Plant Secretary of State of Social Services. And finally, she has to be contactable in all emergencies. And this was highlighted in the case of Whitaker and National Insurance. So these facts so far indicate that she possibly could be an employee. However, on the flip side, there are some facts that indicate that she's more self-employed. Like, for example, she must pay her own taxes. However, this is not necessarily decisive, but it is an indication. And this is from the case of Davis New England College. She can decide what days she wants to work and the hours that she wants to work. So although she has to work 20 hours, she has that flexibility to come in when she feels free to. She has to submit her invoices once she works over 20 hours. And as a skilled individual, companies have less control over those people when they're providing the actual service. And this is in the case of Burloff and Crestrum. And finally, she works for other companies. And this shows some form of independence, that she's not just relying on the work provided by Crate. And this was highlighted in the case of WHPT Housing Association and the Secretary of State for Social Services. The final hurdle is that there must be a provision in the contract stipulating the employee relationship. The facts indicate that she's been labelled as a self-employed individual by the Human Resources Department. However, we need to look further into the terms of the contract and see whether this is actually what occurs in practice. Now, the second part of the irreducible minimum is that the test of mutuality of obligation. Now, this test of mutuality is seen as a prerequisite for a contract of employment to exist. Now, the first part is that there must be a contract at present. Arguably, there's an implied contract between Rhiannon and Crate, as there's no express provisions which have been highlighted in the facts. Nonetheless, we need to look further into the clauses of the contract, because if the contract is drafted to exclude an employment relationship, it can be upheld. However, if the clause is unrealistic as to what actually happens in practice, then the employment tribunal will totally ignore the clause and imply an employee relationship. The second part of mutuality of obligation is that there must be a mutual obligation to offer and accept work. However, if this obligation does not exist between Crate and Rhiannon, then it cannot be said that Rhiannon has an employee status. Even though Rhiannon can choose when and which hours that she wants to do, there is that obligation that she has to work a minimum of 20 hours per week. Therefore, she is under a duty to accept those 20 hours per week. So it can be said that the mutuality of obligation does exist. Further evidence of mutuality, such as the presence of personal service which has been established previously, and also the fact that she gets paid holiday and sick pay. Whether Rhiannon can claim her bonus depends on whether the bonus itself is a contractual right or a discretionary right. Whether the bonus is a contractual right or a discretionary right, the courts will ask whether or not the reasonable employer would have exercised its discretion in that way. And this was taken in the case of Clark Norma International PLC. If Rhiannon intends to stay in her employment, she could bring an action under the lawful deduction of wages. This is under section 27(1) of the Employment Rights Act 1996. We can see from the facts that it's £1,000 which should have been awarded, and since it's a quantifiable sum, the claim for damages can be proceeded. However, she needs to ensure that she brings an action within 3 months to the Employment Tribunal under section 23(1) of the Employment Rights Act 1996. The Employment Tribunal will make a declaration and all the amount which has been unlawfully deducted. Additionally, consequential loss can also be awarded. Alternatively, if she decides to resign, she could claim either breach of contract or constructive unfair dismissal. Finally, the employee could claim a discrimination action, as she is the only person within her company that has not been paid the bonus. It seems as though that Rhiannon has a plausible action, but this will be left to the discretion of the Employment Tribunal or the courts.